Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court Justice, with me, Jill Barton. On this episode, I've asked our AI hosts to describe how to correctly place modifying words and phrases. This grammar topic has played a central role in a few recent U.S. Supreme Court cases. Let's hear about them here.
Welcome to the Deep Dive. Today, we're jumping straight into something really crucial for clear writing, especially in law.
That's right. We're talking about mastering modifiers.
Exactly. And our guide for this is Chapter 21, Modifiers, from Jill Barton's The Supreme Guide to Writing. So we're getting insights from, well, the highest level.
Our mission today, then, is pretty clear.
Let's nail down the key ideas from this chapter so you can, well, immediately make your writing sharper using modifiers effectively.
And Barton kicks off with a great quote from Justice Brandeis.
Oh, yeah.
Modification implies growth. It is the life of the law. Makes you think, doesn't it? Mastering these isn't just about rules.
It's about the clarity, the evolution of legal ideas themselves. Okay, so where do we start? What's the first big principle?
Well, the absolute core idea, the one Barton really hammers home, is simple. Avoid confusion. Place your modifiers close to what they actually modify.
Seems straightforward enough.
It does. And Justice Kagan gave a neat example recently, talking about VIP, that dog toy company. She pointed out different modifiers. Dog toy, that's like an adjective modifying company.
Yeah.
Then a phrase like making and selling a product line. A gerund phrase giving detail. And a clause like that it calls silly squeakers, adding specifics. All modifiers.
And it's wild how often the interpretation of these modifiers becomes the whole point in a Supreme Court case.
Oh, definitely. Barton mentions a few recent ones where this was central. One case was unanimous, actually.
But even then,
Justice Alito wrote a concurrence, basically saying, look, let's not get too rigid with grammar rules if it obscures the real meaning.
interesting balance.
Yeah, and then you had Justice Gorsuch dissenting in another case. He argued the majority read a clause in a way that made it leap over the thing it should logically modify.
Which defies grammar and common sense, he said.
Exactly. You also see this with things like the rule of the last antecedent, like in Lockhart v. United States.
Yeah.
But Barton's main point is cleaner.
Just keep them close.
Pretty much.
Yeah.
Place modifiers so there's no ambiguity. Usually that means right next door.
Proximity equals clarity. Got it. Okay, so that leads into the first specific unanimous rule Barton talks about, avoiding misplaced modifiers.
Right. This is where shifting a modifier, even slightly, can just completely warp the sentence's meaning.
Mm-hmm.
Barton highlights common culprits, words like almost, hardly, just, mainly, nearly, only, predominantly, primarily. Small words, big impact.
Like the word only. That one trips people up.
Totally. Take Barton's example. In a nation governed by the rule of law, only Congress may withdraw this nation's treaty promises.
Okay, their only clearly modifies Congress and no one else.
Exactly. But watch this. Move it slightly. In a nation governed by the rule of law, Congress only may withdraw this nation's treaty promises.
That sounds like withdrawing treaties is all Congress can do, which is wrong.
Right, or Congress may withdraw only this nation's treaty promises.
And it sounds like they can pull those promises, but maybe not other laws. Also not right.
See? One small word, three placements, three totally different meanings.
Wow. Okay, and this isn't just about single words, right? Phrases, too.
Absolutely. Misplaced modifying phrases cause trouble, too. Barton uses the Andrew Beshear example.
Kentucky's Attorney General.
Yeah, the sentence. At the time, Andrew Beshear, a Democrat, served as Kentucky's Attorney General. Clear, right? He was AG then and Democrat then.
Makes sense.
But rewrite it. Andrew Beshear, a Democrat at the time, served as Kentucky's Attorney General.
Huh. That sounds like maybe he stopped being a Democrat later. Creates a weird implication.
Exactly. It introduces potential factual error just by moving the phrase.
So the fix is just keep the modifier as close as you can to what it's modifying, its antecedent.
That's the core solution. And if you've got multiple modifiers...
Then you need a logical order, right? Like how we naturally speak.
Precisely. You want a smooth, clear flow. Justice Sotomayor actually had a great example of managing multiple modifiers effectively.
Oh, yeah.
It was in a complex sentence about mandating contracts with religious schools. She carefully arranged several modifying phrases like to mandate with schools that teach religion, and a longer concluding phrase to maintain clarity.
Even though they weren't right next to the subject, today's decision.
Right. Sometimes bunching them up close would actually be more confusing. It's about the clearest arrangement for the reader. Justice Fennell's testimony is another example Barton uses, showing careful placement of multiple phrases.
Okay, that makes sense. Finding the optimal flow. Which brings us nicely to the next rule. Avoiding dangling modifiers, unless the meaning is crystal clear.
Ah, the infamous dangler. It does paint a funny picture.
So what exactly is a dangling modifier?
It's when the modifier's there, but the person or thing it's supposed to describe its antecedent is just missing from the sentence. Often the subject got switched around.
Gotcha.
Barton's example is pretty memorable, if grammatically shaky. Living and breeding in ponds that are safe for tadpoles, the U.S. Fish and Wildlife Service designated 4 sites.
Huh. So the Fish and Wildlife Service lives and breeds in ponds.
According to that sentence structure, yes. Obviously, we know it means the gopher frog, but grammatically, it's dangling.
So yeah, traditional grammar says avoid these, big red flag.
Generally, yes.
Mm.
But here's where it gets interesting. Barton notes that even the justices and other skilled writers sometimes do use them.
Really? When?
When the intended subject, the actor, is completely obvious from the context. It sort of mirrors how we talk, so sometimes prioritizing flow when the meaning isn't really at risk.
Can you give some examples from the justices?
Sure, Justice Thomas. Having taken that step, one thing is certain. Clearly, the court took this step, not one thing.
Okay, that's clear.
Justice Kagan. Applying our long-standing precedent, the answer is clear. The justices are applying precedent, not the answer.
Makes sense.
Justice Alito. Taking the provision's operative words in turn, the term stay is commonly used. The term isn't taking anything, the interpreters are.
Right.
Justice Gorsuch. Having invoked these sundry considerations, it's hard to see how the majority might disown them. It didn't invoke anything.
So in all those cases, the real actor is implied or obvious.
Exactly. And Barton stresses that the context, often the preceding sentences, usually makes it crystal clear. Like in Alito's example about the Casey opinion, the court was already established as the actor.
Or Gorsuch using I in the sentence right before his dangling modifier, having now effectively abandoned. So you know he's the one abandoning.
Precisely. So the takeaway isn't go wild with danglers.
No, definitely not.
But it's that. Sometimes, when context removes all doubt, even top legal writers might choose a more fluid conversational structure.
Okay, that's a really useful nuance. Which leads us to the final rule. Avoid unclear modifiers by thinking about context and just common understanding.
Right. This is where, as Justice Kagan put it, sometimes just the ordinary understanding of how English works has to win out over super strict grammar rules.
How does that play out?
Well, the Facebook v. Duguid case is the perfect example here. It was all about defining an autodialer.
Ah, I remember that one.
The key phrase was using a random or sequential number generator. Did that phrase modify only the verb produce telephone numbers, or did it also modify the verb store?
So one side argued it only applied to produce.
Yeah, Brian Garner argued for Duguid that if the equipment could store numbers and then dial automatically, even without generating them randomly, it was still an autodialer because the generating part only applied to produce.
But the court didn't buy that?
Nope. Unanimous decision, written by Justice Sotomayor. She said there was no grammatical basis to just pick and choose which verb the modifier applied to. It should apply to both store and produce.
Okay. But then Justice Alito chimed in.
He did, in his concurrence. He brought up some great everyday examples to show that a modifier at the end doesn't always just modify the very last thing.
Like what?
Like a dog wagging his tail loudly. Obviously, loudly applies to the wagging, not the tail itself. Or hunting rhinos and giraffes with long necks.
Only the giraffes have the long necks.
Right.
His point being that common sense tells us how to read these.
Exactly. Our common sense understanding of the world often guides interpretation more than rigid syntax alone.
Context and ordinary understanding are key.
Absolutely. Justice Kagan had some brilliant hypotheticals on this.
Yeah.
If someone wants to meet an actor, director, or producer involved with the new Star Wars movie.
You know they mean someone involved with that movie, not just any random actor who happens to be nearby.
Precisely. Or if you're looking for a house, condo, or apartment in New York.
All three have to be in New York, obviously.
Right. Or a penalty for violating a statute, rule, or regulation relating to insider trading.
It applies to violating any of those three if they relate to insider trading. Common sense dictates it applies to the whole list.
Exactly. And even Justice Sotomayor, in the Facebook case, agreed that common understanding should rule. Her point in the earlier Lockhart case was that the statute there was just so badly written, it didn't align with any common sense reading.
So the bottom line here is prioritize clarity and common sense. Put your modifiers where the meaning is unmistakable, sometimes even if it slightly bends a strict rule.
You got it. Like Kagan said, sometimes grammar has to give way because the meaning is so clear.
Okay, great stuff. So let's quickly recap those 4 big rules from Barton for using modifiers well.
First, keep them close. Place modifiers near what they modify to stop confusion.
Second, watch out for misplaced modifiers. Don't let them accidentally change your meaning.
Third, avoid dangling modifiers unless the context makes the who or what absolutely undeniably clear.
And fourth, avoid unclear modifiers generally by thinking about context and just plain common sense. Ordinary understanding.
Nail those, and your legal writing gets clearer, more precise, and definitely more persuasive.
Yeah, it's not just about ticking grammar boxes. Following this advice actually helps you adopt a more modern, accessible style, like the justices themselves are demonstrating.
Definitely. And maybe a final thought for you, the listener. You might be surprised how much difference that careful placement makes. It's subtle, but powerful.
So as a default rule, follow the grammar rules on modifiers. But keep in mind that common sense prevails, especially when interpreting tricky older statutes. Tune in next time to hear the latest trends on names and titles in Supreme Court writing. And remember, you can be a great legal writer.